We are live and recording.
Thank you. Good morning or good afternoon, everyone, and welcome to the January 23rd, 2026 Committee of Bar Examiners meetings. As a reminder, this meeting is being recorded. I'm calling this meeting to order. Devin, please call the roll.
Bolton.
Good.
Burns.
Present.
Cow.
Here.
Gongora. Kaplan.
Here.
Kramer. Lawrence. Lee. Misiwala. Here. Montgomery.
Here.
Peak. Reed.
Here.
Reyes.
Here.
Reyna.
Here.
Silva Guzman. Here. Smith.
Here.
Yokelson.
Here.
We have a quorum.
Thank you. We have one member appearing remotely today as required by the Bagley-Keene Act, Bagley-Keene Open Meeting Act. Members that are appearing remotely must appear visibly on camera, except if a member is unable to appear by video due to connectivity challenges. If that is the case, please provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. First up on the agenda is call for public comment. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the committee exercises oversight on admissions matters, including the California bar exam, the first-year students exam, moral character applications, and law school regulation. The CBE does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meetings. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider these comments. The committee has received and read all the written public comments, and we thank you for that. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were already made by previous speakers. And additionally, because we have a full agenda today for today's very short meeting now, as chair of CBE, I am going to exercise the option to make a motion to limit public comment to 20 minutes, with each speaker having 2 minutes. Do I have a second? Seconded by Kaplan. Devin, please call the roll.
Bolton. Burns.
Yes.
Cow.
Yes.
Gongora, not present. Kaplan.
Yes.
Kramer. Lawrence, not present. Lee, not present. Misiwala.
Yes.
Montgomery.
Yes.
Peak, not present. Reed.
Yes.
Reyes.
Yes.
Reyna.
Yes.
Silva Guzman.
Yes.
Smith.
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you. For those of you who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom of your center of your screen. If you wish to address the committee, please click on the hand icon below, and the committee coordinator will call on you in the order that hands are raised. For those of you who are participating by phone, you may virtually raise your hand by pressing *9, that is the star key, then the number 9. Doing so will alert staff that you would like to make a comment, and the committee coordinator will call on you and open your microphone so that you can address the committee. For those of you who are participating from the Los Angeles office, please notify the state bar staff member present in the room that you would like to make comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. The committee coordinator will now call on members of the public who signed up in advance. But before we do that, do we have anybody here in the room who wishes to make public comment? Seeing none, Devin, please call on the members of the public who have signed up in advance.
Our first public comment is from Benjamin Cohn.
Thank you. Mr. Cohen, you are recognized for 3 minutes.
Thank you. I wanted to start by addressing the recent presentations that you just heard, and specifically the discussion with Dean Chemerinsky regarding how to address testing accommodations under a new paradigm where the NCBE is the vendor. The mm, the idea that I think that the COVID pandemic circumstances differing from the present circumstances in terms of like maybe the severity of the need for remote testing, the remote testing benefits. Those are things that go more to a policy call over what the standard condition of the bar exam should be and how important it is to do that. Maybe you'll get less testing accommodation requests for it than you would have had there been a standard condition of entirely in person for everyone, which the NCBE did try to force, by the way, in 2020, back before vaccines. It could affect how many people need testing accommodations for their particular disability or what of remote or what disability it is. The differences between where we are now and where we are in 2020, which is not a COVID-free world. It's just it is different, but it's not quite the same as what it was in 2019, for example. The for the need for remote testing. So for all of those reasons, it goes to those things. I don't think it's legally relevant to go to the fundamental alteration analysis. I think that maybe Dean Chemerinsky didn't fully understand the question or was just giving some more general answers, or maybe he did disagree on the law. I don't know. But I think fundamental alteration is whether the exam is a matter of fact, not as a matter of what policy even the legislature has set, but as a matter of fact for purposes of applying the federal law. What would allow it to test the skills or knowledge and what would not. So all these other administrative things about why it's easier or harder or more reliable or less reliable or, costs more, convenience more, safe, to some extent safety wise, all of these things are not things that are fundamental. These are things that go to the more threshold analysis and don't rebut a prima facie reasonable accommodation once one has been established for a particular individual. So I don't think that you'll be able to say it's a categorical fundamental alteration to get out of doing this, and that's my comment.
Our next advanced sign up is a phone number ending in 8294, who I do not see in attendance. Our next advanced sign up is from Jessica.
Good afternoon. You all heard my public comment this morning bringing attention to the fact that the CBE cannot hold the power to reject my study sessions for lack of veracity and then simultaneously disclaim administration responsibility and deny me Chapter 6 protections. In December, I submitted a formal petition asking for clarification on which position the CBE holds, and the Office of Admissions refused to forward it to this committee. I respectfully ask that you address that petition. However, my public comment now is different. I am in the process of repeating the 18 months of study I was unjustly denied, and I will have my 4 years of law office study complete well before the arbitrary July 14th deadline to sit for the July 2026 bar. However, the eligibility office is inexplicably miscalculating my study weeks. The mandatory study session cover sheets state, quote, each 6-month session or 1/2 year of study must consist of at least 18 hours per week for a minimum of 24 weeks and no more than a maximum of 26 weeks. Yet nowhere in the state bar rules nor the business and profession code does it mention 26 weeks. It just says 24 weeks equals half a year. And I have completed 151 weeks of study that has been certified by the admissions office. And by June 9th, I will have completed the required 192 weeks for 4 years to qualify to sit for the bar. Presumably based on the misplaced 26 weeks remark on the cover sheets, I'm being denied 7 weeks of already approved study. There are not less than 4 legal rule-following methods by which I qualify for the July 2026 bar exam, yet the Office of Admissions is going outside of the state bar rules and the law to prevent me from doing so. Please instruct them to correct this. It's not just for me, it is for every law office study student who deals with the injustice of following the rules when you feel like it and not following the rules when you don't feel like it. Please follow the rules. Thank you.
Thank you.
That concludes our advance signups. We will now move to members of the public who wish to make public comment remotely. Next is Ray Hayden.
Hi, how you doing? Ray Hayden from Florida here. I'm really sorry to see that the way the votes rolled out in the previous meeting, but I am happy that the Mr. Tony's amended option came forth, and I hope that that Cal Bar has the opportunity to do that research methodology on that to ascertain the next gen bar exam without the California component, as opposed to using the Kaplan MCQs, which you're already paying for and are going to pay for anyway, to use that as a quote unquote bridge, which could be used to basically evolve California into exactly what you want. Because next gen is going to erase all of your options. You'll have none. But then with the California option protocol, you'll be able to come up with something on your own. There was one more thing I wanted to mention. There is something about the sign up in advance kind of thing. Every now and then, I can't remember which meeting it is. It gives me a difficulty in doing that. So it's basically a technological thing with signing up to speak in advance. One of the forms, and I forget which meeting it is, doesn't work well. Is there anything else I had to say? Well, I hope you have a great meeting, and I hope that you have the opportunity to truly assess the opportunity for going with the Cal Bar option with the Kaplan questions that you have to. There is. That's it. Money. California Bar is hosting in locations and having to pay for those locations. You're operating in a negative multi-million-dollar deficit spending right now. That's not going to change no matter what you do, as long as you have to have the exam in person. Yes, fix the remote possibility. I'll send more information into Cal Bar as I do more research and find more information on that. But you need to get that fixed. And I truly believe that the remote option done right is the way to go, because so many other tests are done that way. Thank you.
Our next public comment is from Kai On.
Good afternoon. My name is Kai On. Attorney General Robert Bonter and Sacramento DA Tian Ho didn't investigate Sacramento DA office provide fake information. DA case file 99F0875. Fake defendant Jungso Fong hit and one kill my father Win Kong On. Sacramento City Council even used a UC Davis internship student to email me fake police report. I went to UC Davis and submit a letter to the Dean of the School of Law. I also protest in front of Sacramento McGeorge Law School, but 2 law schools did not provide help and also ignore the incidents. Yes, political power is controlling the legal system. All members, please work with other legal professions to prevent political power to control the legal system in California. The political power is taking away the justice from the ordinary California citizen. Thank you.
Our next public comment is from Susan Bakshian.
Thank you. I've been attending today's joint meeting, and I would like to make 2 quick points as someone who served on the Blue Ribbon Commission. First, I would like to make sure that those who are hearing and making these important decisions today appreciate that the Blue Ribbon Commission never discussed the use of the Kaplan questions in a California specific exam. That was not an option on the table at the time that we were reviewing the way forward in California. Also, as part of the Blue Ribbon Commission's work, we did in fact reject the Next Gen exam at that time. At that time, absolutely no information was available about what the exam would test, what format it would be in. None of the information available today was available at the time of that recommendation. So I would merely caution these bodies, whether it is the joint meetings or this body of the Committee of Bar Examiners, to be cautious in how they use the Blue Ribbon Commission's recommendations and decisions. And secondly, and my final point I would like to make today, is that I believe the reliance on the bar association's support for a California specific exam is misplaced and somewhat misleading. Gil Pellis, who presented that information in public comment this morning, has an undisclosed personal financial stake in a California bar prep company. He is the person behind baressays.com, a company that will not exist without a California specific exam. I believe that the absence of the disclosure of that personal conflict of interest makes it difficult to rely on his representation that bar associations support a California specific exam. And I thank you.
We do not have any additional raised hands.
Thank you, Devin. First item on our agenda is approval of the December 5th and 6th, 2025 meeting, open session minutes. Do we have any questions or are there any revisions to the minutes?
This is Michael. Let me make that motion.
Second. Okay. Moved by Cal, seconded by Kramer. Devin, please call the roll.
Bolton? Burns?
Yes.
Cow?
Yes.
Gongora, not present. Kaplan?
Yes.
Kramer?
Yes.
Lawrence, not present. Lee, not present. Macy-Walla?
Yes.
Montgomery?
Yes.
Peak, not present. Reed?
Yes.
Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you. Next on the agenda is the consent calendar. There are 2 items on the consent calendar: administrative updates regarding law schools and approval of the report to the Supreme Court on the July 2025 California bar examinations. Do any members wish to pull either of the items off the consent calendar? Seeing none, is there a motion?
I'll second that.
Okay, moved by Kramer, second by Cow. Devin, please call the roll.
Bolton?
Yes.
Burns?
Yes.
Cow?
Yes.
Gongora, not present. Kaplan?
Yes.
Kramer?
Yes.
Lawrence, not present. Lee, not present. Macy-Walla?
Yes.
Montgomery?
Yes.
Peak, not present. Reed?
Yes.
Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you, Devin. Next on the agenda is item 3.1, discussion and action, if appropriate, on recommendations for the 2026 budget. This is being presented by Finance Director Justin Ewart. Could we promote Justin?
Hello. We get disconnected when we get promoted, but thank you for having me here today. I'm Justin Ewart, the Finance Director here at the State Bar. In the interest of time, I know you've all had a long day and you still have a long agenda. I thought I would highlight the differences between what was presented to you last month when we met in December versus what is presented today. And the major change between the two is we got actuals from the February 2026 bar exam. The applicant totals were much higher than we anticipated in December. Donna has previously mentioned that in another presentation, but even after you take out the 699 fee waivers, it was still up 16% from a comparable exam of February in 2024. So that increase in revenue narrowed the deficit. We were about $2 million deficit spending, and it has cut the deficit down to $1.5 million in deficit spending. We also made the change to double the CBE travel budget for 4 in-person meetings. And those are the major changes that happened from December. I'm happy to answer any questions about the budget.
Are there any questions?
Just one, and you could get back to me later, but in the future, could you break out for the indirect costs, how much of that is the personnel related as opposed to other indirect cost sources?
Yeah, we can break down the indirect costs. What kind of breakdown? I guess I'm not clear on the
I'm
ask.
curious to know how much of that is personnel. I suspect it's the vast portion of it, but
Yeah, all our indirect costs are related to. Oh, are you asking like what's charged specifically to FTEs?
yes, I think that's probably a good way to say it. Yeah.
Okay, we can give you a breakdown. I can provide the committee with a breakdown of all the different indirect costs that can be disseminated later.
Okay, thanks.
Anything further? Is there a resolution here that we need to vote on?
Don't we make a recommendation to the
A
full
recommendation.
committee? I'll make that motion if you put it up. Yep, I like that.
Spike, I'll second that.
Moved by Kramer, seconded by Dr. Cow. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora, not present. Kaplan,
Yes.
Kramer,
Yes.
Lawrence, not present. Lee, not present. Masiwala,
Yes.
Montgomery,
Abstain.
Peak, not present. Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 12 ayes and 0 nays, the motion carries.
Thank you. Item 3.2, action on 2026 Committee of Bar Examiners, Committee of State Bar Accredited and Registered Law Schools, and State Law School Council work plans. Donna?
Yeah, I will start. The admissions leadership went through the work plan that we presented to you at the December 5 meeting and updated it based on the input that we received from you on that day. And so I'm just going to point out the items that are new on the work plan. The first thing that's new is actually the first entry on the work plan. This was Kareem's suggestion to evaluate the effectiveness of the Office of Admissions communications with applicants. We were going to assess the survey responses we've already received and bring that to the committee. We talked about bringing it to this meeting, but didn't have time to pull the data and wouldn't have had time to discuss it anyway, so we've identified that as a March 2026 item on the plan. The next new item on the plan you'll find at the very top of page 5. And that is under examinations and exam administration one-time assignments. We actually didn't talk about this at the December meeting, but with staff had already planned to have this discussion, and for some reason it just fell off the work plan. And that's to review and revise as appropriate the bar exam grading policies. We're going to bring that to you at your March meeting. The next thing that was added to the plan you'll find on page 7, and this is under testing accommodations and eligibility one-time assignments. This is in response to a comment that Mr. Kramer made, asking that we review the eligibility requirement that exists in statute and in our rule to assess if there are changes needed. This is the requirement that allows you to sit for the bar exam and be certified to the Supreme Court, not only if you graduated from an ABA law school or California accredited school, but if you studied diligently and in good faith for at least 4 years. Mr. Kramer had raised a question about the sort of lack of specificity of what that means and whether that should be changed, and that he wanted us to discuss that this year, so that if you decided that a change needed to be made, we could advance a suggestion to the legislature to make a statutory change. The next thing that was changed on this work plan, you'll find on page 9, and this is under the educational standards one-time assignments. It is the last block before the blue line of the recurring assignments, and we've changed the wording a little bit here. We had already had on here to consider revisions to the unaccredited law school rules, but we highlighted specifically in response to comments that were made, streamlining the process for addressing non-compliance, and also highlighted requirements for best practices regarding the use of generative AI. And then the final change that we made in the same vein as generative AI was on page 12. We added the second from the bottom, testing accommodations and eligibility. We added in response to Committee Member Smith, exploring whether to add requirements related to the competent use of artificial intelligence to the law office study program, following the consideration of similar requirements for law schools. So we have put that on as a future item to look at AI in the law office study context after we do it in the law school context. Those were the changes recommended for the Committee of Bar Examiners work plan. If there are no questions on that, then I'm going to turn it over to Cody to talk about the CS Bars work plan and the Law School Council work plan.
Seeing no questions, Cody, go.
Yeah, I can keep it brief. What we have done this year, which I believe is new, is bring to the Committee of Bar Examiners a work plan for CS Bars and Law School Council. What you will see in the attachment is essentially snippets of the CBE work plan, and then we worked with the Committee of CS Bars and Law School Council in discussion with them to identify which topics their review and feedback would be most valuable. So the work plans, as far as the topics listed, should be identical. Topics that were either irrelevant or where feedback from our law schools was not deemed valuable have been removed from their versions of the work plan. So it's a lot of the same content, but what you'll see is an additional column on the right-hand side that indicates when we anticipate each of those sub-entities to discuss the topics. The one last thing I'll just add is we had a meeting of CS Bars just 2 days ago, and there was a very strong positive response from our law school deans that they thought that this would really help CS Bars provide more focused feedback and to be better aligned and kind of have a more clear feedback loop with the Committee of Bar Examiners. So far, a good response from our law school deans.
Donna, is there a third?
Nope, Cody handled the 2 and 3 there in his brief sum up. So we have, in case there was any desire to vote differently on each of these work plans, I broke them up into 3 resolutions.
All right. Seeing no raised hands, do I have a motion to approve all 3 resolutions?
Yes, I'll move to accept all 3 of the resolutions.
I'll second it.
I'm not seeing who's, oh, I'm sorry. Vince.
Yes.
There you go.
I'll second. Reed.
Second by Reed.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Bengora not present, Kaplan,
Yes.
Kramer,
Yes.
Lawrence not present, Lee not present, Macy-Walla. Yes. Montgomery,
Yes.
Peak not present, Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 13 ayes and 0 nays, the motion carries.
Thank you. Item 3.3, action on inspection report and jointly accredited status, Lincoln Law School, Sacramento. That'll be Natalie Leonard. Natalie, come on down. Otherwise, come to the table right here.
Perfect. And if not, I'll come up front. We will need Vince though, because he is. Okay, how about now?
Yeah, there we
Great.
go.
Okay, all right, thank you, everyone. So we'll be talking about 3 different schools today. The first school is Lincoln Law School of Sacramento. And this law school was due for its normal periodic inspection, and it also applied for a new status that this committee created, which is jointly accredited status. The purpose of this status is to recognize schools that achieve not only programmatic accreditation through the State Bar, but also institutional accreditation through a national accreditor. Once achieving institutional accreditation, that gives access to Title IV federal funds, and using a jointly process allows the school to lighten its regulatory burden without reducing the oversight that the State Bar has. It also reduces the cost of monitoring and regulating the law school as well. This school has been a consistently strong performer. After this inspection, it had very few recommendations. The requirement for the jointly process is that they show a full accreditation with WASC, which they have done. Their first accreditation was a full 6-year accreditation, which is very rare and an indicator of quality. It will be re-accredited in June, and though that is a future date, by this point, if there were issues raised by WASC, then very likely there would have been some sort of notification at this point, so we don't expect any issue. The other requirement that they need to meet is to fully fulfill the core requirements set forth in Rule 4.147C, which are the programmatic elements that the State Bar retains the role to monitor directly. And at the time of the inspection, the school was very close to doing so, much more than we typically see. And in the ensuing months, we worked with them. They were able to demonstrate full compliance and easily provide all evidence that was needed to show that full compliance. So with that, I would suggest that they appear to have fully met all of the requirements for jointly accredited status, and we do have a motion to show on the screen. Paul or Vince, do you have any other comments as to Lincoln Sacramento?
Oh, just to reiterate that the result of this is that they're not going to be periodically inspected by us anymore. They're still subject to our jurisdiction, though, so if we notice a problem, either reported by some member of the public or in the annual reports, we can initiate an investigation to see if, if we need to do something. But it frees them from the expense and the time that they would spend in a every 5-year or so inspection.
All right.
And they're still subject to our NPR as well, so which is a key indicator.
Natalie, would it be appropriate for 3.3 and 3.4 to be considered to vote on together? Or would you like separate votes?
I think that it would be as to Golden Gate, but for Lincoln Law School of Sacramento, I proposed a single motion.
All right.
That would include both the recommendation and the jointly accredited status. Before you go to a vote, Dean Yurashek, who you met this morning, is also here. I don't know if she plans to make an additional statement, but I believe she just plans to be available for questions. Devin, would you mind if we just checked in with Dean Yurashek?
I do not see the dean's hand raised.
Okay, then we should be fine if the committee has further questions or plans to entertain a motion.
No, can we present the motion?
The dean did just raise their hand.
Okay, thank you.
Yes, Dean. Dean, you were recognized for...
Thank you. I just wanted to thank the staff and the inspection committee. They were very thorough, very comprehensive, and very communicative and helpful throughout this entire year-long process. And I am here to answer any questions, but I wanted to make sure to acknowledge the wonderful staff and Natalie and Cody, and specifically CBE member Vince Reyes, who was on the inspection team. Thank you.
And thank you and congratulations. The resolution is on the screen. Do we have a motion?
Yeah, I'll move the motion. This is Vince.
Second, Burns.
Second, Burns. Devin, please call the roll.
Bolton?
Yes.
Burns?
Yes.
Cow?
Yes.
Gongora? Not present. Kaplan?
Yes.
Kramer?
Yes.
Lawrence? Not present. Lee? Not present. Masiwala? Not present. Montgomery?
Yes.
Peak? Not present. Reed?
Yes.
Reyes?
Yes.
Reyna?
Yes.
Silva Guzman?
Yes.
Smith?
Yes.
Yokelson?
Yes.
With 12 ayes and 0 nays, the motion carries.
Thank you. 3.4.
Thank you. I would suggest that we take the next two motions together unless a committee member would prefer to separate them. They both relate to Golden Gate University. Okay, so with respect to Golden Gate University School of Law, historically the school has been ABA approved. They have applied for accreditation, came before this committee earlier in 2025, and at that point the committee determined that based on their application they appeared to demonstrate a program that would be in full compliance. That program included a full-time JD program, which would be the first year in person, beyond that hybrid, a part-time JD program held during the week that would be synchronous online, interactive online. There was an inspection held in which CBE member Mike Lee joined myself and also Greg Shin for the purpose of verifying the facts in the application and further establishing the school's compliance, as well as looking into a question that the committee had related to an ongoing notice of concern letter that was issued by WASC. And so to address that situation, first of all, total compliance was confirmed. The checklist that was presented to you at the last meeting was deemed to be accurate. As of October, there were several minor changes that didn't affect compliance. Those are listed in the inspection report. And as to the notice of concern letter for WASC, it related to the financial stability of the university as a whole, but much of that had to do with the underutilization of their real estate. And since that time, they've sold one piece of real estate that was not important to them in their educational mission, and they have an option as to their main campus. Should they decide to exercise the option as to the main campus, they understand that they would file a motion for major change to this body in terms of any change of administrative location or change to their program. So based on that, the staff recommendation is to grant accreditation immediately to Golden Gate University School of Law to begin their accredited program in fall of 2026 while completing their ABA teach-out through 2027. It's very common that there would be the tail of an ABA teach-out at the same time that a new CALS program is starting. That happened with Thomas Jefferson and also with the University of Laverne, and both had successful outcomes. So that is the first portion. The second portion is that the law school must file for acquiescence to non-JD programs that it is offering, and it plans to continue to offer two programs that it has for many years, an LLM in taxation, as well as a general Master of Laws. These programs have been offered, that Master of Laws since 2022, and the taxation LLM for many, many years. They are already staffed. Your level of review is acquiescence. Essentially, will it harm the JD program in any way? And since those programs have been offered without affecting the JD program, and the LLM in taxation has a widespread respect and acclaim over many, many years, we would suggest that these can be continued. The final two requests are for SJD programs, Doctor of Juridical Science. You don't see those too often, but that's largely an academic degree or a degree that a business person might undergo when they don't plan to practice law. They have both an internal SJD program that's local here in San Francisco, as well as one that they previously operated with a program called UpGrad, which is located in India and works largely with international students. Neither of those programs is admitting students. If it were to do so again, the school would file another application for acquiescence. Those programs are staffed, those programs have advisors, and those programs have sufficient staff available for their dissertation committee, so we don't believe that they would harm the JD programs in any way. Therefore, there is a staff recommendation to grant. Both of those two motions are available. The two motions might be a little harder to show on the screen, but I do know that Dean Mark Yates is also here and would like to greet the committee.
Hello, am I recognized?
Yes.
You are.
Okay, thank you. I'm sorry. It's a little confusing. I'm going to be very brief. I just want to thank the committee for considering our application, and a very, very special thanks to the staff and Ms. Leonard. I know they worked very hard on this, and I just want to reiterate that we're very excited to become part of the Cal system, and I'm here to take any questions that you might have.
I don't think there are any questions, but
just one.
Julie Smith.
I have one short one for Natalie. Are we voting for the two SJDs? Are we just voting that they exist and in the future might have students, and at that point they would file a report, or what exactly is the vote for those?
It's voting to allow the teach out of those programs. So the international program has about 50 students in it right now, and the local centered one has about 20. They've all completed their coursework. They are ABD. They're all but dissertation. They're completing those research projects, and then once they graduate, the programs will cease. Thanks.
Thank you.
So Natalie, did I hear you to say that if they wanted to enroll new students in those international programs, they would have to make a new request for acquiescence?
Yes, and the reason for that is that these are styled as teach-out programs right now, not admitting new students, so it would be a material change.
So should we add something to the motion to make that clear? Because it's, to me, I mean, it's implied when you say they are not accepting new students, but I think it would be clear to say if they desire to, revive these programs, they would need a new petition.
Maybe we would say if if they plan to admit new students.
Yeah, how about if they plan to admit new students, a new request for acquiescence would be required.
Yes, and I would suggest to say prior acquiescence, prior to beginning.
Prior to.
Yeah.
Paul, is that getting at what you're looking to achieve?
Make that, indent that so it's a bullet under just that one, but.
Sorry, say that again. I can just list these. And
It's SJD and International Legal Studies programs, I guess. No, I mean, I think it's in the further resolved.
Yeah, sorry, I was just.
Yeah, okay.
Yeah, so the first paragraph deals with the programs that are still admitting students, and then the second one is for those two programs that are in a teach-out status, not admitting new students.
Thanks.
Thank you, Paul.
All right, with that, so we're talking about 3.4 and 3.5 together? Natalie?
If it pleases you, yes,
Yes.
you could move the motion that way.
I'm looking for a motion to approve both 3.4 and 3.5. Can I have a motion?
I'll make that motion. Ashley, so.
Ashley Silva Guzman.
I'll second that motion.
Vince Reyes seconds. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora, not present, Kaplan,
Yes.
Kramer,
Yes.
Lawrence, not present, Lee, not present, Macy-Walla, not present, Montgomery,
Yes.
Peak, not present, Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Jokelson.
Yes.
With 12 ayes and 0 nays, the motion carries.
Thank you. Item 3.6, Natalie?
Thank you. So this regards American Institute of Law and Unaccredited Correspondence Law School. Dean Dowd will be here to address the committee after I complete my staff presentation, along with any comments from Paul and Vince. The school underwent its periodic inspection, but it was not a typical inspection. When it was inspected in 2021, the committee determined that the school should not receive a full 5-year term of accreditation. It was later inspected again in 2024, and in June, you reviewed that inspection report. After reviewing that inspection report and its 13 recommendations, you determined that it would be appropriate to issue a warning letter to the school because you had concerns about the school's progress. The school responded to that warning letter, and that's what you have before you today. So the task before you today is to determine whether to accept the contents of the warning letter or to reject the warning letter and continue with the notice of noncompliance process. The staff recommendation was a very difficult call and a close call, but the staff recommendation is to accept the warning letter in part because the law school has agreed to make many systemic changes that have the possibility to improve the performance of the program, but these involve changes that will take time to show improvement, significant changes to the admissions requirements, significant changes to the academic support and the interactive support available to students, significant changes to the bar prep. It is important that the school make this progress, but it does need time to do so. Therefore, the staff recommendation is to accept the warning letter, but to provide a renewal period that would take them to spring 2027 for their next inspection. This would allow the school to have this school year in which they've been aware of the committee's direction, plus next school year, and they would be able to demonstrate whether they have truly been able to improve their performance. They should have the plans in place to determine whether it's possible for them to do so or not. I'm happy to answer any questions. This short presentation encapsulates quite a bit of research and quite a bit of detail in the materials that you have. But Paul or Vince, do you have any additional comments?
Yeah, it's kind of continuation from the last meeting. I think the main things that we were concerned about were the attrition rates, and I do agree that takes a little time to fix. And it's incremental. It's not something that they can just kind of do overnight. It might take a couple of semesters or so. So I would agree with the inspection going on. I guess 2027 was that the year we decided? Yes.
Paul,
Yeah, so if you want to, the school's not on the line, is that correct, Devin?
The school actually will be on the line. It's Mike Dowd, or may appear as Michael Dowd, the dean of the law school.
Then I think well, he's coming up, I think we should show because Vince and I and Natalie made a couple revisions to the proposed resolution just in the last day. So, yeah, I think it's fair to do that, and see if he wants to make any comments.
Thank you.
Okay, actually, Dean Dowd is online. Dean Dowd.
I was going to ask, can you hear me?
We hear you too well, actually.
I'm sorry about that. I'll try to see if there's something on my end that I can do to reduce that volume. The only thing I wanted to say, first of all, is that I'm the sort of the new dean at American Institute of Law. I have only been on board for roughly about a year. When I came on board, I recognized, having gone through the inspection process as a professor at the law school, I recognized that there were some issues that needed urgent attention and to be addressed. I wanted to thank Ms. Leonard as well as the staff for what they did and the questions they raised and the concerns they raised, because they are concerns that I also hold as well. In this last year, we have made some substantial changes. We are continuing to make those changes. We are committed to addressing the concerns that the inspection committee had, and we will continue to do so at the best possible speed. It is at times a slow process trying to revamp an entire system that I've just kind of got on board with in an administrative capacity, but I am committed, as is the president of the law school and the faculty of the law school, to address those concerns. And I think we're well on our way to doing that. And I think that by spring of next year, you will see that we are not only in full compliance, but we should be hopefully ahead of any schedule that anybody could place on us. So I just want to thank you for the opportunity to speak. If you have any questions, I'm more than willing to answer those, but thank you very much.
Thank you, Dean Dowd.
Thank you. Paul, did you have
No, well, I'll just point out the language we added was to specifically call out attrition rates and first-year law students exam passage rate as giving rise to concern about the soundness of the school's educational program. So that's what we're going to be looking at especially. But the other issues that were identified are of importance as well. And the idea is to give the school a little bit of time to show improvement and see where we go from there.
Is there anything further? Any other members of the committee? Do I have a motion? Oh, Julie.
I guess maybe more of a question. Thank you, Dean, for being here. I think the staff is raising some issues that parts of the website are not compliant yet, and I was wondering if there's a timeline for that. I would imagine that updating the website is something that could be done pretty quickly.
It was actually completed this morning.
Thank you. So they're in full compliance.
Yes.
Oh, thank you.
Thank you. Anything more? Do I have a motion?
I'll move.
And is there a second?
I'll second.
Vince seconds. Devin, please call the roll.
Bolton,
Yes.
Burns,
Yes.
Cow,
Yes.
Gongora, not present, Kaplan,
Yes.
Kramer,
Yes.
Lawrence, not present, Lee, not present, Macy-Walla, not present, Montgomery,
Yes.
Peak, not present, Reed,
Yes.
Reyes,
Yes.
Reyna,
Yes.
Silva Guzman,
Yes.
Smith,
Yes.
Yokelson.
Yes.
With 12 ayes and 0 nays, the motion carries.
Thank you.
Thank you.
Thank you, Natalie. Staff reports, item 4.1. Donna?
In the interest of time, I'm going to waive, but I will note that we are now ahead of schedule.
Okay. Well, it's still been a long and productive day. So we go close, right? Okay. So at this time, the committee will move to closed session pursuant to Business and Profession Code Section 6026.7 C3 and 4 and Government Code Sections 11126 C1 and E2A. Shit. Oh, and I would indicate that there was nothing to report from the closed session. If there's nothing further, I declare this meeting adjourned. Thank you very, very much, everybody, for a long and I think very productive day. Thank you.